Any reply, Ms. Fani-Kayode?
I'm going to be very brief, Chairperson.
Yes.
I'm not going to go back to the issues of the plea deal. I've got experience in that regard, and I know it's important. And at some point in time, I will demonstrate to you what the importance of that is.
Yes.
The second thing, my learned friend says that subsequent to the date of the 7th, nothing happened. The affidavit sets out quite clearly what happened subsequent to the 7th. The 13th, we were back in court. There's also the issue on the 8th, the recordings were disclosed and what happened there. So my learned friend is not correct when she says there's nothing. It's been set out chapter and verse what transpired from that date on. And the thing that's quite important, Chairperson, is I don't believe this commission, and I've said it before, as you recall, we're not here to ambush witnesses. And it's for that reason that I'm entitled to ask, if you're in possession of certain material that you wish to use against my client, I'm entitled to ask for it. Because that way, we level the playing field. So it's also, that also needs to be taken into account. Lastly, you were quite right. I did reserve my right twice.
Or just before you move to a different point, wasn't everything that Mr. Matlala required given before the 7th of July?
We said that there must be certain recordings. We then given 13 voice files. We then said it's clear somebody went and extracted, like cherry picked and given us 7 voice files. We now want the complete recordings from which these were extracted. We were then given on the 8th, I think, recordings, 2 recordings. There's in fact a 3rd recording that was not given to us. Then we were handed over, I discussed it with my learned friend, and she made some inquiries. We were given a transcript, an unofficial transcript of the one. So, and these are long. The one is 6 hours and the others together is longer than that. So, and the client must sit and listen to it because he needs to ensure himself. So that process wasn't even concluded. And then lastly, as I said, it's just an issue of, I did reserve my right because I foresaw what was going to happen at that point in time. It was not a condition I will file and then amplify. I just couldn't, because at that point I still hadn't had any access to the client to discuss any of the issues relating to, as I said, let's call it the Medicare 24 matter. One more thing, Chairperson, I'm going to ask you and the commissioners to consider the following. I'm going to ask that we be assisted and that an order is made that we get access to the client over weekends with electronic devices, in other words with the computers, to assist us in dealing with all of these things. It's very difficult if we can't do that. It's the times that you can see the client is limited. There's only a limited number of legal practitioners at any given time that can see the person. And if you were to see in the normal way, there's a thick glass and you can't listen to recordings. So we would like, if there's any way that you see open, that we be allowed for this weekend and the next weekend to get access. After that, we won't need it because the last weekend would be just before the filing. Because we're also starting on Monday, it gets transported, very limited time in court because we're running the trial. So what we can do is we can get drafts exchanged that he can look at that, but to finalize it, we'll also need to have access to him next weekend at the present one.
How is it done for purposes of the criminal trial that's commencing? Is it next week?
We've had consultations long before. It's actually a much simpler matter than anybody has made it out to be. And that's why for that it was easy. We've given the client the dockets that was disclosed, and when we had opportunities, we've discussed with him our defense, our plea. So that was, and we had two person-to-person meetings that was allowed by the head of the unit, so we could actually go in with computers and have those. But for some reason, I think because of what has been transpired, we are not getting access that easily anymore. I can just speculate why suddenly, after things have started going a bit differently. So all I'm asking is if you can assist us in that regard, we'd appreciate it.
Yeah, I think something like that would have to be dealt with administratively. I cannot make a ruling here. But anyway, it's not that I understood you to be asking for a ruling. Because, for example, I do not know what prescripts correctional services may put up and say, we can't comply.
No, so all I'm basically asking,
but that should never be understood to say, after agreement on a date, what happens or does not happen will then be a basis for saying, no, we are not able to file because. Please continue if there are further submissions.
Simple, we will do our best, but maybe something from the Commission side that we should, without making a ruling, that from DCS side, that they should do whatever they can to assist us. I think that would go a long way. That would give us something in the hand to now go and do from our side what we need to do. Thank you. I've got nothing else.
Nothing else.
I agree with my learned friend then that we discuss inter partes the date.
Yes, all right.
Ms. van der Heever, without getting into it, I just want to know its status. The opinion letter, I'm not getting into it. Was it filed just for the purpose of today's postponement? It was to deal with just today.
Oops, doesn't work anymore. Oh, there it goes. It was done for today because of, as I said, that's all I wanted to say.
Yeah, it doesn't go beyond.
There are other reports and things that's been drafted. We have been communicating with the head of prison with regard to the issues, but I don't want to go into that further at this point in time.
It was just for today's postponement.
For
That's
today,
all I wanted
and the relevant part of it, you'll find about the issue of, I mean, you've read it.
Leave it there. That's fine. Thank you, Mansard.
Chair, if I may, for the record, to correct for the record and posterity, Ms. van der Heever speaks of being provided with random extractions from recordings. That's wholly incorrect. The recordings that were provided were recordings that were played in this commission during the testimonies of witnesses. As we do when we provide our Rule 3s, we provide the evidence that implicates the particular witness who served with a Rule 3. Those are the 13 recordings that were played in here. They were not random. Nobody went into the recordings and decided they like the sound of the clipping from 1 hour 15 to 1 hour 17 minutes. So that is one. Those were provided on the 18th of June. They were given to Mr. Matala. It is only on the 7th of July, after the ruling, and their statement is due the next day on the 8th, that they require the complete recordings. And they were duly provided on the 8th. So it is not like information was denied them or we failed to respond positively to any request for information made. Each time it is made, it is given. The inescapable conclusion is nobody listened to those 13 clippings when they were provided, and because if they did, they would have made the determination at that time already that they require full clippings in order to prepare a statement. Thank you, Chair.
Maybe that just on that issue, Chairperson, we immediately on receiving those recordings send it off to an official transcriber. It was in vernacular. It then had to be typed up and then transcribed. And then upon seeing the client with the computer, it's only then that we realized that these were extracts from various other recordings. And it was only at that point that we could approach the commission, the evidence leader, my learned friend, and say we want the full recordings, because we were then informed that it's extracts from other recordings.